This is Bentley Tolk. Welcome to another episode of the ERISA Litigation channel, where you can keep current on the latest ERISA cases. Today we're going to talk about the plan documents rule, and specifically with regard to a Fourth Circuit decision that expounds on some of the complexities of the plan documents rule. The case we're going to talk about is Boyd versus MetLife Insurance Company, which is 2011 U.S. App Lexus 6605. It's a Fourth Circuit case from March 31st, 2011. In that case, the decedent had named her husband as the primary beneficiary in a life insurance plan that was sponsored by her employer, Delta Airlines. The decedent later separated from her husband, and a family court entered a separation and property settlement order. Pursuant to that order, each party gave up any right to receive life insurance proceeds from the other's death. Now, the decedent's ex-husband signed the agreement whereby he gave up any claim to life insurance proceeds due to the decedent's death. The decedent, however, never changed the beneficiary designation on file with the plan administrator, which in this case was MetLife. After the decedent's death, her mother, who was the contingent beneficiary under the plan, and her estate filed a claim for the life insurance benefits, as did the decedent's ex-husband. Relying on the plan documents rule, MetLife determined that the ex-husband should receive the benefits. The estate and the decedent's mother appealed the benefits denial in writing, but MetLife upheld the denial. The decedent's mother and her estate filed this action for benefits in federal district court, and the district court granted MetLife's motion to dismiss, concluding that MetLife had followed its statutory duty by awarding benefits to the beneficiary who was designated in the documents on file with the plan. The decedent's mother and her estate appealed that dismissal to the Fourth Circuit, and the Fourth Circuit, in the Boyd case, affirmed the judgment of the district court. In doing so, the Fourth Circuit relied on the Supreme Court's Kennedy decision from 2009. In that case, the Supreme Court interpreted 29 U.S.C. section 1104 A1D as a wide-ranging endorsement of the plan documents rule. That section, 29 U.S.C. 1104 A1D, says that employers must distribute benefits in accordance with the documents and instruments governing the plan. The plan documents rule says that plan administrators look only at the directives of the plan documents in deciding how to disperse benefits. The ex-husband signing the waiver in front of witnesses didn't matter, contrary to the argument of the estate, even though the ex-wife in Kennedy was merely a party to a court decree divesting her of the plan proceeds. In other words, it didn't matter that there was an actual signature in front of witnesses by the ex-husband. Now, it also didn't matter that the life insurance plan wasn't a pension plan, as in the Kennedy case. The plan documents rule applies both to welfare plans and to pension plans, according to the Boyd case. What was key in the Boyd case was interpreting footnote 13 in the Supreme Court's Kennedy case. In that footnote, it states that the Supreme Court's ruling didn't address a situation in which the plan documents provide no means for a beneficiary to renounce an interest in benefits, which wasn't the case in Kennedy. There's some indication in the Boyd case that if there were a provision that basically said that a beneficiary couldn't renounce an interest in benefits, then things might be different. But footnote 13 in Kennedy didn't help the decedent's mother or the estate, because even though they argued that the life insurance plan at issue didn't contain a formal means for a beneficiary to renounce an interest in benefits, it didn't matter. Here, the ex-husband didn't want to renounce benefits anyway, and he was claiming the benefits. Further, as shown in the Kennedy case and in the law of spendthrift trusts, which Kennedy addresses, an ERISA beneficiary always retains the option to renounce benefits at the moment of distribution. The plan administrator in this case was not authorized to disregard a valid beneficiary designation form, where the beneficiary was not disclaiming his right to benefits. The key point to take away from the case is that plan administrators aren't required to examine waivers that are extrinsic to plan documents. Requiring administrators to do so wouldn't be good policy, because they would have to determine the enforceability of the waivers, whether it was voluntary, whether everything was in order. In addition, benefits disbursements would be delayed, and administrators would expose themselves to a multitude of litigation.